Items for pronouncement of judgments. Item number 50, Criminal Appeal 244 of 2023.
Appeal dismissed.
Item number 51, Criminal Petition 9 of 2024.
Petition allowed. Impugn judgment and order set aside in cost.
Next slide.
Yes.
Item number 35, my lord. I beg to mention on behalf of the learned engaged counsel, my lord. Matter may kindly be
Who is
taken up.
the engaged counsel?
He does, my lord. Actually, they are from outside of Guwahati, so due to personal reason, they could not reach.
On the pair, on the, Mr. Your good name?
K. Kolika.
Learned counsel appearing on behalf of Mr. D. Das, learned counsel for the applicant. Press for listing the matter after.
On the next Wednesday.
Lordship, diary not received, so 24, madam.
24.
Interim may kindly continue.
On that day, learned
Is still, no?
Yes.
additional PP shall produce the case diary before this court. Till then, interim order passed earlier shall continue.
Obliged.
Meet with your lordship. Lordship, free for listing of a matter, criminal petition, the earlier was a continuation delay. petition.
When,
Lord, might be in the first week of June, as per the convenience of my lord.
yes.
5th June.
Maybe, highly advised.
Yes, please, my lord. One AB, my lord, I have filed tomorrow, my lord. So matter may be listed on Monday, my lord.
Monday not possible. Monday, Tuesday not possible. Oh, Wednesday, Thursday, Friday, you can take any date.
So
Madam.
Wednesday, my lord.
Okay.
22nd.
Wednesday.
May please lordships. One regular bail application, my lord. He is in jail, my lord. Petitioner is in jail, my lord. His exam will be commenced from 20th of May, my lord. On Monday, from Monday, his exam will commence. I filed the bail application on 13/5, my lord. Last
Why,
13/5.
why,
Already
why,
numbered. His, my lord,
why you have not filed the petition earlier?
my lord, just arrested on my lord, not to so much risk, my lord. Around, my lord, tomorrow, my lord, at 2 p.m, my lord.
Tomorrow.
Today, my lord, I'm sorry, my lord.
Not possible today.
Otherwise, my lord, his exam will be commenced from my lord.
Who is responsible for the same?
My lord, he
Sorry.
ought to have been.
Any date next week?
Then my lord, Monday, my lord.
Yeah, exams.
BA, my lord, 6th semester, my lord.
Monday.
Monday, my
Yes,
lord,
next
was
item.
probably automatically listed, my lord. I would not like to mention. Monday, if possible, my lord, then
Yes.
yes, oblige, my lord. Monday, sir. Much.
May I please, your lordship. Lordship, I beg to mention for listing of an IA, lordship. It was filed on 9/5/23 for modification of order, lordship. He is in custody, lordship.
24th.
24. He is in custody, lordship.
22nd if possible.
He was granted bail by this honorable court, lordship.
Okay. Tuesday,
Tuesday, lordship.
Tuesday.
21st.
Obliged, lordship.
May I please your lordship? Lordship, I beg to mention of a criminal revision petition number 526 of 23 on 28 May. Please, Your Honor.
May I please your lordship? I beg to mention the matter of criminal petition number 188/2015, 608/2016, and 602/2000. All are analogous matter, and the matter was lastly listed on 19/7/2017 for admission.
When
And
do
admission
you
is
want?
over and list the matter for hearing. And
When do
after
you
that,
want?
yes, my lord,
When do you want?
for hearing.
Hearing,
It's a-
there is no column
it's a,
for hearing. my lord. What is the exact position of the case, my lord? We have to see.
it was lastly
You go
listed
and
on, I
approve
have checked.
you go and approach the registry will list the matter for hearing.
Mention of
In usual
hearing of
course.
column.
It was not listed for a long time.
The order
That's why I
should
have
go.
mentioned this
You
matter.
file
Order
a
should-
file an
order should go.
application.
For
before
orders,
the-
your honor.
Pardon?
My lord, for orders. if possible, because the last order is not uploaded in the online system. I went to the criminal petition system. According to them, they have not found the last order. But
you made the joint register. Joint register judicial.
এবার চেক করে দিবা।
I have checked. Yes, sir. I have checked in the the order was uploaded in the old software system, and then I have found that the last order was listed on 19/7/2017.
You go and resolve the matter with the registry. Yes, next item.
May I please your lordship, may I please your lordship, I beg to mention item number 42. Lordship, I want to withdraw the case as because the petitioner has been arrested.
What is your name?
P. Kapoti.
Ms. P. Kakote, learned counsel for the applicant submits that the applicant has already been arrested and as such the matter becoming infectious. And as such, she paid price for according her permission to withdraw the same. Permission is allowed. This AB is displayed on withdrawal.
May I please, your lordship, I like to mention 4 transfer petition, lordship. 3 were granted stay by this honorable court, your lordship, but the lower court, in spite of the stay matter, your lordship, they have proceeded with the case and warrant has been issued against the petitioner, your lordship. Kindly date me fix on Monday, your lordship, or Tuesday. Yes, all transfer petition, same petitioner, your lordship.
On Monday, we have lot of matters.
On Tuesday, your lordship. Warrant has
Tuesday
been
also, we have lot of matters.
warrant has been issued against the.
Monday, Tuesday, not possible.
Yeah, your lordship, warrant has been issued, your lordship.
Hmm?
Warrant has been issued, your lordship, because
Maybe.
there's an urgency, your lordship. And he's also not well, your lordship. He has been admitted at hospital, your lordship. He is having some renal problem, your lordship.
Monday, Tuesday, not possible. Because there is also division bench.
All are analogous, your lordship.
Cases on
Court of
Wednesday.
problem to
cases on
Unlawful.
Friday. 2 cases on 22nd and 2 cases on 24th.
All 4 on Wednesday, your lordship, then.
Okay, we will try.
All 4 Wednesday.
Witness,
Deeply obliged.
May I please, your lordship, I beg to mention an IA, lordship, for listing next week, any date, lordship.
Okay, take a date from.
22nd.
Obliged. May I please, your lordship, I would like to mention item number 41, as CD has been not received.
Okay,
yes, she did not receive my, so Gorsuk, local mailer,
Mr.
ordered mailer 24.
B.B. Gogoi learned additional PP submits that he has not received the case aid. Accordingly, it is provided that Mr. Gogoi shall produce the case aid before this court on
24.
24th.
May I please, your lordship? Lordship, I beg to mention for listing of a matter on Monday for withdrawal, lordship.
Withdraw.
May I please, your lordship? Lordship, I beg to mention for listing of a criminal petition, your lordship, on 24th,
On
24th, your lordship, criminal
24th.
petition,
Friday.
Possible?
27, taken on 27,
27.
Monday.
My pleasure, lordship. I would back to mention listing of criminal revision petition 487/22. The matter was last listed on 28/9/2022. Thereafter not listed for listing on Friday, madam.
Next Friday.
24th.
May I please, your lordship?
Hmm.
I beg to mention item number 28.
28 charge sheet submitted.
What is the number?
Yes.
Charge sheet number 27/24, dated 29/4/24,
Under section?
under section 376(3)/448/506 and POXO 4.
You want to pursue the matter here or before the trial court?
কি কৰিবা? ট্ৰায়েল কোৰ্ট ট্ৰাই কৰা প্ৰথম, তাৰপিছত নহ'লে ইয়াত আহিবা।
Go to trial court.
Trial court. Okay. We'll dispose of the petition.
Obliged.
Items from daily list from motion bail application. Item number 1.
May I please, your lordship? My lord, it's a case under section 3665. Punishment provided 7 years. So, my lord, I refer to page 18, my lord.
When he was arrested,
I was arrested on 18/3/2024. So as on today, my lord, I have completed 60 days. my lord.
60 days.
Yes. And punishment is 7 years, up to 7 years, my lord. So it comes under subsection-
Where is the FIR?
my lord, FIR.
13. Page 13.
Page 13, my lord.
Where is the certificate copy of the order? No, order of the FIR?
Hello.
Certified copy.
Certificate copy.
Original.
Yes, my lord, at page 15.
15.
Yes, ma'am. সম্মানপূর্বক নিবেদন এই যে
এই
অনুমান 3 মাহ পূৰ্বৰ পৰাই মোৰ নাবালিকা ভনী বেগম 1 বছৰ লগত 1 নং পদকীয় জনৰ লগত বিয়াৰ কথা কয়। She herself said, but thing is this, my lord, she is minor. That is why the guardian did not allow to marry. And your lordship would be pleased to see one agreement also between the parties, my lord.
Let us do one thing. Mr. Gogo, you obtain instruction from the officer in search
Yes.
whether any section has been added to this
Yes,
section or
my
not.
lord.
At
Because
two-
the
at
victim
2
is
o'clock.
minor.
My lord,
At 2 o'clock.
oblige, your lord.
Number 2.
Wait, the lordship.
Yes.
Well, the lordship will find the petitioner is a lawyer by profession, my lord. And he has done some misdeed, my lord. So that's from Jorhat, my lord. He's done misdeed. I agree to that. My only thing, the custodial detention, and also, my lord, both the sections were below 7 years, 7 years and below, my lord. 41A notice has not been given, my lord. So that number one is whether my custodial detention is necessary or not, my lord. Allegations are very serious, my lord. Allegations are serious, my lord, and in fact, lordship will find forwarding report that is at page 13, my lord. Your lordship will find what he did, my lord, being a lawyer, my lord.
Let us sit a case diary.
My lord,
We will fix a very short time.
my lord.
Gogo, Monday, would it be possible or Tuesday?
22, my lord, 22.
22.
Jorhat, my lord.
20.
My lord. Well, he has did something wrong, my lord, which we
No,
should
the
not.
thing is that if we grant bail to him right now. it
No,
will
yes, my lord,
simply-
that I understand, my lord. In fact, my lord, I asked personally, that what is the reason for doing these things, my lord? It's not for the money, my lord. It's what he did. Having a practice of 14 years practice, my lord, and I don't know why he has done all these things, my lord. This is not permissible. I think the bar council also take actions against him.
He has admitted everything.
Yes, admitted. He admitted. Everything has been seen. That your lordship see the case there.
Yes, 22.
What is there?
22,
Milord?
22.
Everything case diary will-
What is there? Milord? Exactly only 2 point custodial detention is necessary or not, and 41A notice. Milord.
No, that's all right.
That notice
We
is-
will also say if the investigation is completed or not.
My
If
lord.
completed, definitely we will consider.
My
it.
No, which issued and he appeared.
Much obliged.
Number 3.
Four 39 application lodge.
Yes, madam.
439 application lodged. Here.
21C
See, my lord, the diary required.
from which PS, DRPS.
Yes, lordship.
Okay, CD on Google.
Yes, my lord.
5 seconds.
গুৱাহাটী জিয়াটো নে কৰ লিখোতে একো লিখা নাই কেনেকে ৰেডি কৰা petition 23rd, my lord.
No, are you sure that it is Guwahati GRP?
Yes, Lordship.
Wait, 20?
Drafting to account carefully করবো না,
Because we have.
Where-
we
what
have
is
got all the
GHY you have
Yes,
in
Lordship.
the title,
24.
Lordship,
23rd,
fix it in the second week of June.
so
Lordship.
23rd is hearing. Yeah, then Monday, Monday next.
Next month.
27.
27.
Very.
Item 4,
Yeah, he got. Yeah.
May I please, Your Lordship? 21 C, Your Lordship. Cancel may be from
From which court? NCB,
NCB Lordship.
Guwahati.
NCB Guwahati.
When he was arrested?
Arrested on 19/12, 2020.
Have you served copy of the petition to NCB?
I am on behalf of M. Rahman.
No, you ensure that you have furnished a copy to the NCB. We'll take it up after some time.
Yes.
We'll go inform Mr. Kayan.
item 5,
May I please, Lordship? Lordship, this matter may be taken up with item number 16. Both are, FIR is the same, my lord.
Item number 6,
16,
16.
16. Lordship.
Yes,
May it please, Your Lordship. Lordship, in this, Lordship has taken up 16 or 5, Lordship.
5.
5. Lordship, what has happened in this case, Lordship? These are two petitioners, Lordship. And one case has been filed against them. One is arrested, the other is not arrested. For the arrested person, item number 5, and for the item number 16 is for anticipatory bail. Same as a hard Lordship. What has happened, there has been a dispute between the two parties in a land dispute, Lordship. Then when we have filed a case against them, Lordship would find at page number 26. Page number 26, Lordship. That is my brother Siraj Ali has filed a case against Ahad Ali and Fatima Begum. Now this Fatima Begum has filed an FIR against me saying all these allegations, Lordship. The allegation, Lordship, would find at page number 14.
Okay, let the city come. The victim is a deaf and dumb person,
Yes.
deaf and dumb lady.
Yes, Lordship. Yes, Lordship. Now, with
Google
regard-
city on.
Lordship,
Supervisor, yes. Oh, yes, madam.
Today is 17th, Lordship. On 24th, Lordship.
24. 24.
Lordship. No,
On 27th, then. Lordship.
27.
27th.
Now, Lordship, with regard to 16, Lordship, may kindly see, Lordship,
Hmm.
what is the state? I was not even there in the incident. I am the person who is working in Guwahati in a hotel. Lordship, may kindly see page number. Lordship, may kindly see that, Lordship.
Page number.
Lordship, in item number 5, Lordship.
No, 16.
No. Item number 5. We have already taken a decision that the CD will be required.
CD on 25th.
Yes, Lordship. But Lordship, in
Yes,
with
item number 16, yes.
I'm the father, Lordship.
Hmm.
And I was not even there in the incident, Lordship. I may be protected, Lordship. No, allegation prima facie is false because if Lordship will see, I have been given a certificate that I was not even there. Me and my father has been incriminated. I'm an old person, Lordship, and my son has been arrested.
Your name is there in the FIR.
Yes, Lordship, because only two, me and my son. My son is arrested. From the record, it says
We'll
it's a-
see the case there.
Lordship, kindly grant me an interim, Lord.
No. Victim is a defendant.
Lordship, that's
Lord.
the delegation, Lordship. Delegation will be there,
We'll
Lordship.
see.
Punishable for less than 7 years is mandatory. Here, none of the offenses punishment is more than 7 years. How can they say that I'm not entitled to a 41A notice? Well, this is one. Now, your Lordship will see my order of remand is at page 32. This is my bail rejection, my lord. Page 32, your Lordship got it, my lord.
Yes.
This is by the learned CJ, my lord. Accused person, namely Bikas Beri and Nikhil Agarwal, have been produced after completion of police remand for 3 days. I have produced the forwarding report and other relevant documents such as interrogation register, inspection memo, etc. And the same are found to be satisfactory. There is no visible sign of injury on the body of the accused person, and the accused persons are prima facie found to be mentally and physically fit. The IO has also produced the case diary. Scene 1 petition wide number 195 of 24 under section 452 CRPC filed by one Sanjay Medi praying for Jimma of the vehicle, so and so. Then your Lordship will kindly turn to the next report. Accordingly, call for report. Then the next report. I have also seen the report from the IF. He has submitted 4 numbers of treasury channel and 1 inventory with regard to the seized amount of rupees 83,64,830. Keep the same with the CR. Seen another petition filed by one Ritesh Jain on behalf of the accused Nikhil Agarwal praying for releasing the said accused person on bail. The engaged counsel for the bail petitioner submitted that on 2/5/2024, at around 2:45 AM, the investigating authority arrived at the residence of the accused Nikhil Agarwal and conducted illegal charge operation without any probable cause and suspicion. The engaged counsel for the petitioner submit that the accused Bikas Beria was arrested for his alleged involvement in IPL betting. But the present accused Nikhil Agarwal has no link or relation with Bikas Beria and has no knowledge whatsoever with regard to any IPL betting. It is further submitted that during the charge of the house of the accused Nikhil Agarwal on 2/5/2024, the investigating authority has recovered a sum of rupees 62,80,890 from the possession of the accused Nikhil Agarwal by breaking the lock, and now investigating authority is attempting to link the recovered money with Sri Bikas Beria and the alleged crime of IPL betting. As for the engaged counsel, the amount recovered from the residence of the accused Nikhil Agarwal are not the proceeds of any crime but legal and counted money which was earned from the legal business transaction of the said accused and part of which belonged to him and other family members which was kept for safekeeping in the almari. It is submitted that accused Nikhil Agarwal have been falsely implicated by the investigating authority, and the investigating authority motivated by malicious intention is trying to establish the link between the amount recovered from the residence of the accused Nikhil Agarwal, accused Bikas Beria and IPL betting. The engaged counsel further submitted that accused Nikhil Agarwal is not an FIR name accused nor he has any connection with gambling or betting. The engaged counsel further submitted that no notice has been issued under section 41A CRPC to accuse Nikhil Agarwal, which is mandatory as per the guideline of the Honorable Supreme Court in Satyendra Kumar Antil versus CBI, reported in 2002 SC Online 825, as well as Arnesh Kumar versus State of Bihar 2014 8 SCC 273. It is further submitted on behalf of the accused person that the FIR does not reveal that the accused Nikhil Agarwal has ever received any money online from any people or bookies or committed any criminal breach of trust, and there is no any material on record.
So where is the material part?
Your Lordship will see. Ultimately, my lord, the Honorable Court says that, my lord, I am also not entitled to 41A notice and bail petition rejected. Now, your Lordship will see the explanation that I have given for my cash. I am a person who is a sole proprietor of a plastic industry.
business. Trading of paper.
Trading, that your Lordship will find, sorry, my lord, at paragraph number 3, page 3, paragraph number 2, your Lordship will see my credentials, my lord. Your Lordship will see accused petitioner is the proprietor of Ganpati Plastic situated at 80 Road, Tinsukia, and is engaged in the trade of tripal, carpet, agarbatti, agronar, etc. It is pertinent to state here that accused petitioner is a primate. Now your Lordship will see that I have the written explanation of this whole case transaction. I have given my balance sheet from balance sheet, provisional balance sheet, as well as the bank transaction.
Mr. Kuhar, we are not concerned with the source of this money, but we are concerned with your involvement in the offense alleged in the FIR.
Yes, but no
So-
notice under 41A has been given.
Okay, let the city come.
Now, your lordship will
Right,
see,
okay.
your lordship will see this Vikas Beria, he was arrested on me on the same day and he was granted interim bail. Just because I did not engage the same counsel as Vikas Beria, I did not mean that my bail will be rejected. Your lordship will kindly see the bail order at page 82. This is a cryptic order given by the learned court below, my lord. At page 82, your lordship will see.
No, you are not against that order before this court, right?
No, your lordship will see. The co-accused person who have been arrested, who is the prime accused, have been granted interim bail. Your lordship will see. The words itself, your lordship will see. Accused Vikas Beria is allowed to go on interim bail of rupees 20,000 with 2 COTs of the like amount with condition that so and so. No reason, nothing, my lord. This has been downloaded from the court website, my lord. Page 82. At least the learned CGM has given the rejection, grounds of rejection for my bail. Your lordship will see page 82.
No, nobody is approaching this court
83.
against this order.
83 also, your lordship will see.
No.
83 also see.
What purpose will be served?
My lord, this is a matter which needs to be investigated. I'm with utmost respect. This needs to be investigated. My lord, how can the court grant, my lord, to in a day in a
No, we don't know whether this is the complete order or.
my lord, this has been
part of
downloaded.
the order.
This has been downloaded from the court's website. I don't know, my lord, whether this is a complete. I'll go by the which is available online, my lord. And your lordship will see at page 82, he has been granted on interim bail, the prime accused. And with me, I have no connection with him. And he has also filed an application before the magistrate at page 69.
Mr. Kaur, let the city come. Perhaps this order will be available in the case area also. We'll see.
But I'm told, my lord, that I think appropriate application needs to file. I'm told, my lord, that this is happening in Tinsukia, my lord, which is very sad reflection. If orders are given in this way, without any citing any reason, your lordship has seen the order of the learned CJM, at least rejection, he has given the ground. We can approach it. But if you give the co-accused, the main prime accused, interim bail, and you reject the person, the other person, just because the counsel is different, my lord, this is not fair.
No, may not be.
Hmm.
May not be.
And even the main accused, my lord, how can you link it? My lord, page 69, the main accused has also filed an application before the concerned court saying that I have not implicated my accused. So how the police can, for that also he has paid an inquiry, my lord.
On 27th lordship,
Sorted.
then lordship on 22 lordship.
22. Mr. Kaur, you remind me on that day about this page number 82.
My lord, in the meantime, I will also try to get, but I'm told, my lord, the atmosphere there is very vitiated. My lord, I may have to file an application before the vigilance section of this honorable court to take an cognizance of this. My lord.
Prior to that, you obtained the complete information in respect of this.
I don't have but the word that is being circulated in the court is very sad reflection. My lord, we don't want to be part of it, my lord. That's why, my lord, I don't have concrete evidence. That's why I'm not saying many words. But the message inside the court campus is very bad about this additional district judge number 2, my lord.
Okay.
Deeply obliged. 22nd.
Number 8.
May I please, my lord, this is a writ petition. And my grievance is that the petitioner has lodged an FIR on 28/11/2020. And on the basis of that particular FIR, the case has been registered against the respondent number 5 under section 120D 448 and 468. Now, my lord, till date, almost 3.5 years has expired, my lord. Till date, neither charge sheet nor any final report has been submitted before the concerned court. This is my grievance, my lord. And the fact of the case is that, my lord, the father of the petitioner, he has acquired a property through a family settlement deed. And from his father, my lord, the father of the petitioner, he has got a particular property through a family settlement deed, and from his father, it is the petitioner who got the property in his name. And thereafter, my lord, the petitioner has now been residing at Calcutta for his business purpose, taking the advantage of his absence from the Tongla town, my lord. The respondent number 5, along with his late husband, they have executed a gift deed, and in the gift deed, the husband of the respondent, number 5 has gifted the property of this particular petitioner to the respondent number 5. On the basis of this allegation, my lord, we have lodged an FIR, but till date, no action has been taken. So I am requesting the learned state to take appropriate instructions regarding the up-to-date status of the investigation regarding the PS case number 177 of 2020 before the Tongla police station.
The problem is that your pair number 3 in the petition
Yes,
to direct the respondent number 2 to submit search it. So can such a pair be made?
My lord, that particular.
If there is no material, how can the court direct the IO to submit search
My
it?
lord, let the investigation be completed. And thereafter, my lord, it is at the police is at the liberty either to file the charge sheet or to file the final report. But they have to come up with something before the court. My lord. It is one of the basic duty of the police to either to file the charge sheet or final report. If during the course of investigation no material is found against the respondent number 5, then yes, they will file a final report. Then I have a chance to file a Naraji petition.
Okay,
But
madam,
without
you
doing
are
anything,
appearing
they're
here?
simply sitting idly. in
Yes,
the police
madam.
station.
Yes,
You are
Lordship,
appearing,
I'm
sir?
appearing for the state of Assam on behalf of Mr. D. Nath, Lordship.
So you produce the case area before this court will see.
Lordships.
Heard Mr. B. Dekal, learned counsel for the petitioner, and Ms. Your good name, please.
M. Devi, Lordship.
And David, learned
Government advocate.
government advocate for the state respondent. State respondent number 1, 2, and 3. This writ petition under Article 226 of the Constitution of India is preferred by the petitioner, namely Santanu Ghosh, praying for following reliefs. Pair number 13, point number 1, 2, and 3. Mr. Deka, learned counsel for the petitioner, submits that the petitioner has lost one FIR on when you have lost the FIR.
28/11/2020.
Where page
That
number?
my lord will find at page 49. For the officer in charge, police station Tongla. Page 49.
49. No, on 28/11/2020. With the officer in charge Tongla police station. Then upon the said FIR, the officer in charge Tongla PS has registered a case being Tongla PS case number
Right, 177 of 20. That is on page
177 of 2020 under section 120B 448 468 IPC. The grievance of the petitioner is that though the FIR was lodged on 27 May, no, sorry, on 28/11/2020, yet the investigation has not yet the concerned IO has not completed the investigation. And therefore, Mr. Deka submits that the respondent number 1, 2, and 3 may be directed to obtain necessary instruction in respect of the present status of investigation of the Tongla PS case number 177 of 2020. Having heard the submission of learned advocates of both sides, it is provided that Ms. Devi, learned government advocate shall produce the case diary before this court on after 10 days,
Lordship, 2 weeks.
after 2 weeks. Suggest one date. In the meantime, also issue notice to the respondents. Returnable on COVID.
On 5th June.
No formal notice is required to be issued to the respondent number 1, 2, and 3, since Ms. Devi, learned counsel, learned government advocate appears and receive notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Notice upon respondent number 4, 5, and 6 be issued by registered post and also by usual process within a week from today. List on points.
Deeply obliged, my lord.
Item 9.
May I please, your lordship? 482 application, my lord, for passing the trial proceeding, my lord, which is pending, my lord, judicial measure first class, my lord, Nogam, my lord, in PRC number 1125 of 2019, my lord. My lord, under section 295A, my lord, which is punishment up to 3 years, my lord. But this case is pending, my lord, since, my lord, 2019, my lord. Later, my lord, in the year of 2022, my lord, the Government of Assam Judicial Department, my lord, published a notification, my lord. According to notification, my lord, the decided to the withdraw the case, PT case, my lord, minor case, my lord, which is up to punishment 3 years, my lord. Now this, my lord, this case is under up to 3 years punishment, my lord. Now, my lord, in the according to notification, my lord, I have filed the additional affidavit, my lord, by supporting the notification, my lord. My lord, kindly the come page number 39, my lord, that is notification, my lord. Annexure 9, my lord, page number 39 of the additional affidavit. 39, my lord. Page number, annexure 9. Additional affidavit.
Yes.
My lord, according to this notification, my lord, my case is a PT case, a minor case, my lord. It should be quashed, my lord. According to notification of dated, my lord, 21st October 2022. Judicial Department already decided, my lord, to go for the withdrawal case, my lord. Which trial is going on, my lord, up to 3 years punishment, my lord. That should be withdrawn, my lord.
Yes, yes, madam.
Section 295A, my lord, is it punishment under 3 years, my lord?
No, whether this notification whether on the basis of this notification you can file a petition under section 482 CPC.
Yes, yes.
How?
482.
How?
3 years of a non-delivered, final.
Whether this notification creates any legal right in your favor?
Yes, my lord.
Protected line of right.
295A section, my lord, is punishment under 3 years, my lord. And up to 3 years, my lord, case should be withdrawn, my lord. According to notification, my lord. They are clearly mentioned, my lord.
Where the case is pending?
My lord, judicial measure first class, Nogam, my lord. Being PRC number 1125 of 2029, 19, my lord, 2019.
Section कितना mention कर दिया? Section mention कर दिया.
Section
Yes, madam.
Yes, up to 3 years.
Lordship, notice.
Hmm? Whether you obtain instruction from the concerned PP of that usually a PP filed the petition.
Yes, my lord. My lord, maybe, my lord, issue notice in the meantime, my lord, that trial may be suspended, my lord. Let's call for LCR, my lord. It come, my lord, in details, my lord, from the concern, my lord, done. Trial court.
In this, heard Mr. S. Roman, learned counsel for the petitioner, and Ms. N. Das, learned additional PP for the state respondent. In this petition under section 482 CRPC, the petitioner has read for causing the criminal proceeding being PSC case number 1125 of 2019 pending before the Court of Learned Judicial Magistrate First Class Nagaon. Mr. Roman, learned counsel for the petitioner submits that the said case was surseated under section
295A.
295A, where the maximum punishment prescribed is up to 3 years. No, read with section 67 IT Act
No, madam.
also.
After, when the IOs submit charge sheet, my lord, there is a delay, my lord, the IT Act, my lord. Only, my lord, the case, trial is under, my lord,
295A.
must kindly see the page number 23, my lord, it is mentioned, my lord.
Page
There is a
number?
Page number 23, my lord. Code is just text 2, my lord, under section 295A only, my lord. 23, main petition, my lord. Annex of 3, my lord, page number 23, it is mentioned, my lord.
Two 295A, I see. Mr. Rohan further submits that in the year 2022, on 21/10/2022, the government of Assam has issued a notification being notification number, page number
Page number 39, my lord, of my lord, additional affidavit.
notification number E-217-005 of 52 dated 21/10/2022.
Yes.
For withdrawal of cases where punishment is up to 3 years or fine or both under the IPC or any other special acts except the following categories of cases. This para number on page number 40. There are 10 lines are there. You incorporate those lines. This yellow page mark. The grievance of the petitioner is that in spite of issuance of that notification by the government of Assam, the case of the petitioner has not been withdrawn. And the proceeding is pending before the Court of Learned Judicial Magistrate First Class Nagaon. And the next date is fixed on when?
As your honorable court thinks it, my lord.
No, next date is fixed before
Oh, my
the
lord, on trial, my lord, 18 June, my lord.
18th of June.
18 of June.
Having heard the submission of learned advocates of both sides, it is provided that let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Ms. N does learn additional CP appears and receive notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Ms. Does the learned additional PP shall obtain necessary instruction in the meantime from the where you will obtain the instruction.
Instruction from
10 days.
Lordship 10 days time have been given. Lordship.
Ms. N does learned additional PP shall obtain necessary instruction as to why the case of the present petitioner has not been withdrawn by the government in view of the notification number dated so and so so and so. List the matter after 4 weeks.
Well, in the meantime, my lord, maybe suspend matter. My lord, petitioner research from under Soiva PS in the district of Kamrup, my lord, it is.
Registration also call for the scan copy of the record from the learned court below. Let us first examine the matter. We will stay there. Let the record come.
Let the CD come, Lordship.
Oh, interim relief at this instance. So let the CD come. CD on.
CD on 28, Lordship.
Page 14, that notice was issued under section 41A. And investigating officer also felt that custodial reason probably is not required. But my prayer before Lordship is that because Lordship, I received the notice lately, so I could not appear. I had to go from Guwahati.
Go and explain.
CD on 28, Lordship.
Sort that.
Then Lordship 27, Lordship.
Item 55.
Obliged.
May I please, your Lordship? Lordship, this is for 38 application. FIR starts from page number 13, your Lordship. May I read the FIR, Lordship?
Yes.
প্রতি মাননীয় মৰিগাঁও জিলাৰ আৰক্ষী অধীক্ষক মহোদয় সমীপতো ৰেজিষ্ট্ৰেশ্যন নম্বৰ S01E8747 মটৰচাইকেল চুৰি হোৱা সন্দৰ্ভত মহোদয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 11/1/2023 তাৰিখে 1 নং বৰচলা জামে মছজিদৰ ধৰ্মীয় সভাত মই মোৰ মটৰচাইকেলখন ৰাখি ধৰ্মীয় সভা শুনি থকা অৱস্থাত মটৰচাইকেলখন চুৰি হৈছে। এই সন্দৰ্ভত উক্ত দিনা বৰচলা আৰক্ষী চকীত এখন এজাহাৰ দাখিল কৰিছিল। তেতিয়াৰ ভাৰপ্ৰাপ্ত বিষয়াৰ কথামতে 12/1/2023 তাৰিখে মটৰচাইকেল বীমা কৰোঁ আৰু আৰক্ষী ভাৰপ্ৰাপ্ত বিষয়া ঘটনাস্থল পৰিদৰ্শন কৰি সাদ্দাম হুছেইন, মইনুল হক, ইজাজুল হক, ৰাজিকুল ইছলাম আদি ব্যক্তিসকলৰ সাক্ষীবাদী গ্ৰহণ কৰিছিল। আজিলৈকে মই মোৰ মটৰচাইকেলখন পোৱা নাই। যোৱা ইংৰাজী 29/5/2023 তাৰিখে উক্ত মটৰচাইকেলখন 7002325691 নম্বৰত ব্যৱহৃত মটৰচাইকেলখন ৰামকৃষ্ণ দাস চন অফ সুভাষ দাস ব্যক্তিজনে কাৰ্বি আংলং জিলাৰ বকুলীয়া ঘাটত ড্ৰাইভিং লাইচেন্স দেখুৱাব নোৱাৰাৰ বাবে 1000 টকা জৰিমনা কৰি মটৰচাইকেলখন মালিক মোৰ নামত চালান কাটি আৰু দ্বিতীয় কাৰ্যালয়ৰ পৰা 14/2/2024 তাৰিখে মোক অৱগত কৰে আৰু উক্ত জৰিমনাৰ টকা আদায় দিবলৈ জনায়। বৰ্তমানলৈকে যিহেতু মই সেই মটৰচাইকেলখন পোৱা নাই, সেই বৰচলা আৰক্ষীক যোগাযোগ কৰোঁ আৰু 11/1/2023 তাৰিখে দাখিল এজাহাৰখন GD এন্ট্ৰি বা পঞ্জীয়ন হোৱা নাই বুলি জানিব পাৰোঁ। এই সন্দৰ্ভত যোৱা ইংৰাজী 22/2/2024 তাৰিখে আপোনাক এখন লিখিত আবেদন দাখিল কৰিছিলোঁ আৰু উক্ত আবেদনখন আপুনি বৰচলা আৰক্ষীক চকীত প্ৰেৰণ কৰিছে যদিও এই পৰ্যন্ত কোনো ব্যৱস্থা গ্ৰহণ কৰা নাই। My simple admission, Lordship, is the petitioner before your honor is not an FIR name accused. Is not an FIR name accused, Lordship. Lordship may kindly peruse page number 15, your Lordship. FIR name accused Mr. Subhash Das was already arrested on 29/4/2024 and he was released on bail on 3/5/2024, your Lordship. And Lordship, stolen vehicle was already recovered, your Lordship. May I read the para, Lordships? Peruse the case that it has been seen that the stolen bike has already been recovered and the seizure has been prepared. It is also seen that case that is not uploaded since 29/4/2024 on date of arrest of the accused person, Lordship. So, Lordship,
Your name is not there in the FIR.
My humble
Why
submission-
you are apprehending arrest?
Lordships, the FIR name accused and I belongs from same place, Bokulia Ghat, Lordship. I have a tea stall. The FIR name accused sometime visit my tea stall and he paid some 500 rupees on my GPay number, your Lordship. After he getting arrested, police came to my place and asking me to appear before the IO, your Lordship. I am ready to cooperate with the investigation, your Lordship. So I may be protected, Lordship. Because I have a
Let him appear before the, let him appear before the. As the vehicle is already
Heard,
recovered.
Mr.
as a board, your Lordship.
Learned counsel for the applicant and also heard Ms. Andas, learned additional people for the status conduct. Apprehending arrest in connection with Lahore PS case number 57 of 2024 under section 379 IPC. This application under section 438 services filed by applicant Harisuddin for grant of PSP. The above noted case has been registered on the basis of an FIR lodged by one Ikramul Islam on 22/3/2024. So a sense of allegation made in the FIR dated so and so is that on 11/1/2023 his motorcycle was stolen from stolen which he kept parking in front of number 1 Borsala Jame Masjid. The learned counsel for the applicant submits that the applicant is no way involved with the offense alleged in the FIR and the main accused of this case has already been arrested by police and also granted bail by the learned
SDGM, Morigaon.
learned SDJM within the get S Morigaon by order dated 3/5/2024 and that the stolen motorcycle has already been recovered and seized by police and that he is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. On the other hand, Ms. Endas learned additional case submits that this is case that may be called for. But having heard the submission of the learned advocates about the parties, perusal of the case is found to be necessary and accordingly it is provided that case there be called for fixing the matter on
5th of June, Lordship.
5th of June. But in the meantime, considering the submission of learned advocates about the parties and also considering the nature of accusation and the punishment prescribed for the same, this court is inclined to extend the privilege of interim period bail to the applicant till receipt of the case. It is provided that in the event of arrest of the applicant in connection with Lowry got PS case number so under section so he shall be released on interim period bail and executing upon the witness 50,000 as considered taken up to the satisfaction of the arresting authority. Therefore, privileges however subject to documentary condition. As condition, he shall not leave the jurisdiction of Susan Morigaon without prior permission.
Itu cuma
We can fix it after some time. I will check it.
Okay, at 2 o'clock.
Record was called for you.
Yes.
And initially the affair was challenged by the petitioner, your lordship. The case is that one affair was registered so moto, declaring one popular front of India as a ban organization, and this petitioner is a president of the said organization. And also the official, lordship, can you complete page 13?
13.
Page 13 of the application. The Gazette of India, which was published on the subsequent day, in which the organization was declared as ban. But one day prior, the affair was lost. It was a ban organization. That is a dispute. When affair was lost, the organization was.
Well, when the affair was filed?
I guess, Lakshmi Kali come to page 10 and 11.
10 and 11.
10. 11 at the bottom. It was lost by Golok Talukdar, SI Police Udalguri on 27/9/2022, and Lakshmi Kali turned to page 13. The official notification was published New Delhi, Wednesday, September 28. Very next day, it was declared as a ban organization. They had the information, but they have registered a case against me. And also amended petition was filed as per order of this honorable court. And also the amended copy was supplied to me on today itself. I will go to the transcript and
Okay, if we agree to your submission, then only these sections 10 and 13 will not come into play. Rest of the sections? IPC offenses 120B, 153.
around 28. I will come because the amended petition was supplied to me on today itself. I have to go to the charge sheet. It has been annexed along with the amended petition.
You have filed amended petition?
Petition.
When?
4/1.
For?
4th of January 2020. And the copy is.
But it is not available here. Amended petition, yes.
Amended petition.
Yes.
Along with the
Yes,
charge
yes,
sheet.
yes.
Along with the charge sheet. If possible, immediately on 20, I will come prepared. 28th of this month. Because I have to go to
28th
this,
of this month.
Possible.
How is it possible?
30.
Mr. R.P. Hazarika, learned counsel for the petitioner, submits that he may be granted 2 weeks' time so as to enable him to go through the search sheet of the present case. Where is accordingly allowed search sheet of
Circuit number 18. 80.
Udalguri PS case number 135 of 2022. Under section 120B, 153, 153A, 153B, 504, 505, 507 IPC, within section 10/13 of the Unlawful Activities Prevention Act 1967. There is allowed, SSL is the matter of 38.
30. Outline. I don't think anyone.
Appeal against conviction, Lordship. Lordship, may kindly admit the appeal. The appeal is yet to be admitted and call for the answers. I is there, Lordship. I number 255.
First, Mr. R. Dora, learned counsel for the appellant, and Mr. P.S. Locker, learned additional PP for the establishment. Judgment and order dated 29/8/2023, passed by the learned Special Judge Vilasipara in Special Poxo case number 38 of 2019. Is impugned in this appeal under section 378. No, 374 within the two, regular section 482 of the Code of Criminal Procedure. It is to be noted here that by the impugned judgment and order dated so the learned trial court has convicted the appellant under section 4 of the Poxo Act and sentenced him to suffer rigorous imprisonment for 8 years and also to pay fine of rupees 10,000 with legal stipulation. And also convicted him under section 376 IPC. Here is the memo of appeal and the grounds mentioned therein. And also there is the impugned judgment and order dated 29/8/2023. Admit. Notice be issued to the respondent. Returnable in 4 weeks. Respondent number 2. No returnable within 4 weeks. Step upon respondent number 2 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. P.S. Locker learned additional PP appears and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Registration call for the scanned copy of the record from the call for the record from the learned court below. List the matter after 4 weeks. Is there any IA?
Lordship, I number 245.
In IA takedown, intern there will be considered after receiving the record from the Lordship.
22.
Yeah, please, madam. My lord, I have gone through.
I have gone through the, you have gone through the
LCR, my
record.
lord, and I have flagged marked some order sheets, my lord. My lord, that matter, if lordship remembers, my lord, the proceeding was split up, but while passing the judgment, my lord, the person was acquitted, my lord.
Yes, Locker, have you gone through the record?
Lordship, I haven't gone through entire record, Lordship. The judgment I have gone through, Lordship. But
Which
Lordship,
judgment?
here in this case, Lordship,
This is not judgment, this is order.
Lordship,
Against order.
Lordship, sorry.
My lord,
You have not gone through it.
Entire record I have not gone through.
Not the entire record. Yes.
my lord, I have flagged marked some portion of the order sheets, my lord.
Yes, sir.
My lord, he has appeared lastly, my lord, on 31/2020. He was absent with steps 31/2020 order, my lord. That is at page number, my lord, 102 of the order set, my lord. The name of the petitioner is Vijay Gupta, my lord. There are other accused persons, my lord.
Lordship, then when the main subject matter is Lordship, then that this person's case has been splitted from the main case, Lordship, and subsequently this case has been the main case has been disposed of, and
he is acquitted.
He has already been acquitted, Lordship.
But the non-violable warrant of arrest is pending against him. Issued in the split up case. That is his case.
Even if non-variable order is recalled, Lordship, then also, Lordship, what will happen, Lordship? Even if non-variable order is recalled by this court, Lordship, even then also, Lordship, whether this the second case will proceed, will not proceed, Lordship.
Which one?
The second case, Lordship, the splitted case against him, against this case, Lordship. Once the main case
his case was split up as he was absconding at the relevant point of time. Thereafter, he appeared But the splitted case remain. There are warrant of arrest being issued. That is the case. But subsequently in the main case, he has been
He is
acquitted.
acquitted also.
No, my lord, may I correct it, my lord?
Hmm.
My lord, once he was, my lord, after my lord, 30 January 2022, he has not appeared, my lord.
Judgment to his officer.
My lord, judgment was passed subsequently.
Judgment was pronounced thereafter.
My lord, 31 2020, he was absent with steps. Thereafter, no steps, my lord. And 1 to 21, that is at page 105 of the order sheet, my lord. 105 of order sheet, my lord, I have flag mark. 1 to 2021.
Hmm.
NBWA was issued against this petitioner, my lord. 1 to 21.
Hmm.
So he had last appeared 30 January 2020. Thereafter, he has not appeared in the proceeding. My lord. Split order is at page 106. my lord.
It is.
Hmm. Yes.
Also, this is it is only against recalling of NBW lordship.
Yes.
Then lordship may pass order because lordship in main case he has been acquitted lordship.
Acquitted. Oh. Heard Mr. A.K. Gupta, learned counsel for the petitioner. Then Mr. P.S. Lawcourt, learned additional PP for the state respondent. In this petition under section 482 CRPC, read with section 401 of the Code of Criminal Procedure, the petitioner, namely Sri Vijay Gupta alias Vijay Kumar Gupta, has challenged the correctness or otherwise of the order dated 19/4/2021 and 28/6/2023 passed by the learned special judge Lakhimpur, North Lakhimpur in special within bracket VIG within bracket capital T case number 01 within bracket A of 2010. It is to be noted here that by order dated, impugn order dated 19/4/2021, the learned court below has issued non-violable warrant of arrest against the petitioner, and by order dated 28/6/2023, the learned court below has issued non-violable warrant of arrest against the petitioner along with proclamation and attachment. Mr. Gupta, learned counsel for the petitioner, referring to the judgment of the learned special judge North Lakhimpur in vigilance T case number 01, which indicated capital A of 2010, submits that the learned special judge has acquitted the petitioner from the charges under section 120B, 420, 407, 409, 468, 471, 34 IPC. And under section 13(1), which in bracket D, Roman 2, stroke 13(2) of the PC Act. Mr. Gupta further submits that While order dated 19/4/2021, the learned court below has splitted up the case against the present petitioner, as he could not appear before the learned court below and issued non-bailable warrant of arrest against him, and also issued notice to the bailor. But subsequently, the petitioner appeared before the learned court below, and the learned court below had framed charge against him, and thereafter by judgment and order dated 38/6/2026, the learned court below had acquitted the present petitioner from the charges mentioned herein above. Mr. Gupta further submits that, but the supplementary proceeding initiated after splitting up his case, white order dated 19/4/2021, the learned court below had issued non-bailable warrant of arrest against him, and thereafter by impugn order dated 28/6/2023, the learned court below had again issued non-bailable warrant of arrest along with the proclamation and attachment against the present petitioner. Mr. Gupta, referring to the judgment and order dated
36/2023.
38/6/2022 passed by the learned court below, submits that the petitioner has already been acquitted by the learned court below, and as such, thus warrant of arrest issued against the petitioner by impugn orders dated so and so, and also the proclamation and attachment may be recalled. And to set aside the aforementioned proceeding, Mr. P.S. Lokur, learned additional PP, submits that since the petitioner had subsequently appeared before the learned trial court and stands trial, and since he has been acquitted by judgment and order dated 38/6/2022.
Sorry to interrupt there, Malad. Malad, he had not, after Malad 30 January 2022, he had not appeared before the court, Malad.
Pardon?
After 30th January 2020, Malad, this petitioner had not appeared before the court, Malad. Once Malad NBWA was issued, then he has not appeared. Before COVID, he was appearing. After COVID, he had not appeared, Malad. So actually the trial conducted in his absence, and even the judgment, everything in his absence.
So at the time of judgment, he was not there.
Okay.
But the order and judgment of the court below is
It says, my lord, he is acquitted, but order said, my lord, and I have also asked him, he says, my lord, after COVID, he has not appeared before the court, my lord. That statement I have also given in the petition. That is the why difficulty, my lord, because even if, my lord, I appeared before the trial court, my lord, the trial court cannot alter its judgment, my lord. Because 362 CRPC says, my lord, except for the arithmetical or clerical error, court cannot alter its judgment. So once in one part, I
no, now what is your pair?
My lord, my prayer is to set aside the supplementary proceeding, my lord, in view of the judgment, but lordship has recorded that I submitted, that subsequently I have appeared, but I have not appeared, my lord.
Acha.
That part I want to correct.
No, during the time of admission of this petition,
Lord,
you have submitted that.
my lord, that perhaps, my lord, wrongly recorded, because at that time, my lord, I submitted that I have appeared at the time of framing of charge, this petitioner was there. Thereafter, my lord, subsequently, when the COVID struck, at that time, it was at the stage of evidence, my lord.
Better you go to the trial court.
So, my lord, I will approach the lordship and kindly set aside this entry
Your
of-
this warrant of arrest issued against
My lord,
against you, we will kept it. We will direct it to kept it, keep it abeyance.
Yes, lordship may direct, but my lord, only difficulty is that, my lord, 362 CRPC, my lord. If lordship.
No, that is the problem of trial court, not my problem.
That's a
Not problem of this court.
Yes.
How can the court resolve it? Let him resolve. Because in this petition, we cannot embark into the such inquiry.
Yes, yes.
Astra hai to ki karo, no? No, line to Harry Potter. Mr. Gupta, learned counsel for the petitioner, submits that the petitioner appeared before the learned court below till 30th/1/2020, and thereafter he defaulted, for which the learned court below has issued non-violable warrant of arrest against him, and thereafter split it of the proceeding against him. But Mr. Gupta submits that white judgment and order dated 30th/6/2022, the learned court below has acquitted the present petitioner also, though he had not appeared before the learned court below after 30th/1/2020. Since the petitioner has already been acquitted in the special vigilance P case number 01 of 1 which will get a 2010. This court is inclined to dispose of this petition by directing the petitioner to appear before the learned court below. And to pass necessary order in respect of issuance of non-violable warrant of arrest against him, and also the warrant of also the proclamation and attachment issued against him within a period of COVID.
Not June. Some more
Till
time.
then, the warrant of arrest issued against the present petitioner and the proclamation and attachment shall be kept in abeyance.
My lord, I pray for at least a 3 weeks time because he is residing in UP. At
Where?
least he is residing in Uttar Pradesh, my lord. So at least 3 weeks time he will appear and file necessary application. My lord.
12 June. In terms of about this criminal petition and further, considering the length of detention of the accused in Jailazut, the scrutiny of the view that his further custodial detention may not be required in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the learned civil judicial magistrate bowing out, the accused be enlarged and bail. CDB returned.
Deeply obliged.
365/34. Also not added. And such it submitted on 14/4/24.
My lord, I have completed 60 days, my lord, under exercising power under 439. Your honor can grant me bail, my lord. As there is.
When charge sheet was submitted?
14/4/24. Arrested on 18/3. Wording.
So within the period of 60 days, charge sheet was submitted.
My lord.
So the question of default bail does not arise here.
My lord, my humble submission before your lordship. Offence is under section 365 as such my lord. So my lord, I am already in detention for.
Okay,
60
okay.
days.
Okay.
So under
Heard Mr.
439, your
Learned
lordship can grant me.
counsel for the accused and also heard Mr. B.B. Gogoi, learned prediction VPP for the state respondent. This application under section 439 is prepared by one Sabur Ali, who has been languishing in Jailazut in connection with Bilasipara PS case number 67 of 2024 under section 365/34 IP6. Who has been languishing in Jailazut since 18/3/2024. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Rakibul Islam on 16/3/2024. The sense of allegation made in the FIR dated so and so is that on 14/3/2024 at about 7:30 PM, Sabur Ali and Zuran Ali have kidnapped his daughter from his house and kept her confined in some unknown place. Mr. Sheikh, learned counsel for the applicant, accused submits that the accused was arrested on 18/3/2024 and since then he has been languishing in jail for more than 60 days. And that the maximum period of punishment that can be imposed under section 365 CRPC is 7 years. And as the accused is languishing in jail for more than 60 days, he may be granted bail. On the other hand, Mr. B.B. Gogoi, learned additional PP, obtaining instruction from the IO concerned, submits that the IO has completed investigation and submitted charge sheet against the accused under section 365/34 IPC on 14/4/2024. Further, since charge sheet has been submitted against the accused after completion of investigation, and since the accused has been languishing in jail for 60 days, this court is of the view that further custodial detention may not be warranted here in this case, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned subdivisional judicial magistrate Bilasipara, the accused and person by.
Obligation.
Standing item 4.
Yes, have you served copy of the
Notice only
petition?
served, lordships. Notice only served to the NCB lordships.
But no, copy. No, NCB.
I can. NCB. 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 NCB reference.
NCB method. Yes, sir. Postmaster will inform the council. Wait for some time.
Standing item 10.
Wait, please allow. My lord, this is quashing of the FIR, my lord, which was registered by Fukuragram PS case number 18/2024 under section 498A, a read with section 4 of the Dowry Prohibition Act, my lord. Let me kindly see the FIR, page 13. My lord, against the husband, father-in-law, my lord, mother-in-law and sister. So my lord, similar allegation with that similar another my lord, CR case was filed earlier, my lord, which I annex my lord, page 20. Almost similar allegation, my lord, and that case was pending for evidence. So is this amount, my lord, second FIR?
No, that case was filed under which provision of law?
My lord, that was filed. Charge was framed under section 498A and 406. Same allegation, my lord. Only added, my lord, he subsequently married another one.
What happened to that case?
Well, that
Complaint
evidence
case?
stage, my lord, after charge. I have annexed, my lord, this order also, my lord. Lordship may kindly see. The page 37 is the, my lord, cognizance taken, my lord, against
Page number 30?
page 37, my lord. So thereafter, my lord, it was fixed for evidence. And next date is, my lord, on 3/7/2024, evidence after charge. And this was filed, my lord, this in the year 2024. My lord, exactly similar allegation, my lord, demand of my lord dowry and my lord,
The FIR of present case?
present case is page 13, my lord. Type copy is page 13, my lord.
18 is vernacular.
Vernacular is, my lord, lordship will find page 18, my lord.
Complaint case was filed in the year
But complaint is filed in the year 2021, page 20, my lord. CR number 213/2021.
heard Mr. J. Uddin, learned counsel for the petitioner, and Mr. For us, no, Mr. P.S. Lawful, learned additional PP for the state respondent. Number 1. In this petition under section 482 CRPC, the petitioner has tried for closing the property against PS case number 18 of 2024, corresponding GR case number 110 of 2024, registered under section 498A IPC, dated section 4 of the Dowry Prohibition Act. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. Stake upon respondent number 2 be taken by registered post and also by legal process within a week from today. No further notice is required to be issued to the respondent number 1 since Mr. P.S. Locker, learned additional PP appears in this notice. However, extra requested copy of the petition be furnished only during the course of the day. Mr. Uddin, learned counsel for the petitioner, submits that in connection with identical offenses, the respondent number 2 here in this petition in the year 2021 had lost one case, being serial case number 213 of 2021 against the same accused persons of the present case, and in the said case, the learned trial court has taken cognizance of the offense under section 498A, struck 406 IPC, and now the case is pending for. Why that case is pending? CR case.
Yes, my lord. Evidence after charge.
Oh, evidence after search. Evidence after search. Mr. Uddin further submits that this second this FIR on the same subject matter is not maintainable, and therefore Mr. Uddin contended to stay further proceeding of occurrence PS case number 18 of 2024. Yes, Mr. Locker.
Allegations are more or less similar.
Almost similar. Mr. P.S. Locker, learned additional PP, also fairly submits that the allegation in the FIR of present petition and the complaint case, and the complaint in the complaint case number 213 of 2021 are almost same. Almost same. Be that as it may, the registrar call for the scan copy of the record of CR case number so from the court of learned.
SDGM Bilashipara.
SDGM Bilashipara, and Mr. P.S. Locker, learned additional PP shall produce the case before this court on next date. Until returnable that further proceeding, further investigation. That what is this police case is pending? Investigation.
When we filed, it is still in investigation stage. Investigation stage.
Going on.
Going.
Further investigation of GR case, no, Procedural PS case number 18 of 2024 stands state.
Obliged.
Standing item 13.
For instruction.
My lord, inspection not received, my lord. We communicate this message to Borpeta Police Station, my lord.
So on Monday then,
Monday.
Mr. B.B. Gogoi, learned additional PT submits that
21.
the notification, no, sorry, the information instruction as required by the order dated 9/5/2024 is not available with it. And price for granting him 2 more days. Here is allowed, rest is the matter on Monday.
Timing item 52.
Yes, extremely sorry, Lordship. This was for the timing, Lordship, T20 PTD.
Lordship, instruction I have received, Lordship.
Pass.
Instruction is that, Lordship, the case has not been registered yet, but an inquiry is going on, Lordship. Case not registered.
Sir, KK does a learned additional PT submits that as per his information, no case has been registered against the present applicant. Investigation is going on in respect of which
At Guwahati Panbazar Police Unit, within brackets, special cell for women. At
but
Panbazar.
one FIR has been received to that effect. Complaint has
It
been
is not
received to that.
stated here, Lordship. It here only stated, but an inquiry is ongoing against him at Guwahati Panbazar Police Unit.
Not investigation, inquiry is going on. Accordingly, it is provided that Mr. KK does learn that additional PP shall produce the status of the inquiry being conducted against the present applicant on Wednesday.
Lordship,
Wednesday.
I will tell you.
Timing 53.
Lordship. Kindly password for the timing, Lordship.
Timing item 19.
Lordship, we have received we have not received the report, Lordship. I have talked with the OC concerned, Lordship. He will furnish it, Lordship. Lordship may kindly fix it on any day, Lordship. Monday or Tuesday or any day, Lordship.
Actually, my lord, phone number of mobiles, my lord, is stolen. Then, my lord, police seized the mobile, my lord.
Okay,
Yes, sir,
let
my
the
lord.
report come. Mr. Locker learned additional PP submits that he has not received the report. And price for granting not that there is accordingly allowed. Let's list the matter on Wednesday. Wednesday.
Item number 29.
Yeah, please, your lordship.
Yes.
This is the 439 application in connection with ACB PS case number 31 of 2024. Under section 120B, read with section 7, small a of Prevention of Corruption Act, your lordship.
Lordship, after some time, Lordship, K. Busher has gone through the record. He is in the record.
Yes.
Item 30.
May it please your lordship. Lordship, here the FIR relates to stealing of 2 cows from the residence of the informant, lordship. And subsequently, 3 different cows were seized from the residence of the petitioner, lordship. And those cows were newly purchased by the petitioner. Lordship, I have annexed the sale and purchase vouchers at page, lordship, 28, 30, 3 cows, lordship, and 32. Those were duly purchased after paying due consideration.
Where is the FIR?
FIR is at page, lordship, 11.
And moreover, Lordship, if allows me to place an order, Lordship.
So, page number 13 is the FIR, vernacular copy.
Yes, but page 13, particular Lordship.
And this page number
Casually.
11 is the translated copy.
Translation copy, Lordship, 11.
11. Is it correctly translated?
Lordship, the word casually, Lordship, some problem.
It is
Lordship.
yellow color.
Casually.
I have not seen any yellow colored cow. Have you seen Mr. Das?
Lordship, what is there in this CD, Lordship? CD is there on one person who sleep Bhattacharya, in whose position this car was in this position, Lordship. And accordingly, he said that he's a travel agent. He has given his car to Aziz. And this Aziz has stated that 4 persons name, Lordship. And they also admitted that they have stolen the cow, Lordship. And they have sold it to another person, Lordship, whose name is Biju, Lordship. And who in turn sold the cow, Lordship, to another person. This is Hanaf. He has also accepted that he has bought this cow, the stolen cow, from this person.
But the cow was recovered from the present petitioner.
At present, Lordship, the cows which are recovered, it is not this cow, Lordship. When the house search is made, Lordship, these cows are found.
But three different cows, Lordship, in respect of color, Lordship, and those were purchased by me, Lordship. And moreover, Lordship, if it allows me, Lordship, I may be allowed to place an order, Lordship, bail order of Biju Ahmed, Lordship, where the progress of the investigation can be reflected, Lordship.
No, when this person was arrested?
28/4, Lordship.
And
order
what is the
reflects that-
stage of investigation?
Lordship, this person has stated only these things. The recovery is not there. In the case that it is stated, Lordship.
But here, Lordship, may I read the order, Lordship? I have placed it. It appears that the LA stolen cows were already seized in this case. This is the observation, Lordship. Already seized in this case along with the vehicle which was used to take away the LA stolen cows.
Yes, Mr. Das, you check the diary.
It is bull, Lordship, one brown color bull. And this is cow, Lordship.
Third para, Lordship.
Third para, that is the defense case.
Yes. On perusal of CD, it appears that the LA stolen cows were already seized in this case along with the vehicle which was used to take away the alleged stolen cows.
Yes, Mr. Das.
Lordship, I'm looking into that. There are 3 cows are there, Lordship. And one brown bull is also there. Lordship may look into the CD.
This schedule is that page number 22.
I have given Lordship.
No, in this.
Page number 20.
Petition. Oh, petition.
Gray colored cow, brown colored cow, bull or bull.
Combination of black and white lordship, gray color, brown color. One bull is there in the possession of Zakir Ali. But in the CD, it is not directly stated that lordship is, in the CD lordship, it is not directly stated that recovered, it is recovered what is not there. Lordship. From the stolen cow has been recovered or not, it is not clear.
Of
Lordship.
the session just
Whether the stolen cow has been recovered or not, it is not clear, lordship. I admit that, lordship, cows are there. But stolen only 2, lordship, and there are 3 cows. And bull is also there.
These 3 cows were purchased by me, lordship. I have NXD sell and purchase vouchers from the market, lordship. These are 2 different cows, lordship, in respect of color.
when he was arrested.
Lordship, 28/4, page 15, lordship, forwarding report. Even from the forwarding report also, cow have been said to be recovered. Lordship.
Okay,
From the forwarding report also.
Page number
15, lordship, 15. This is stated. Ground 4. Lordship, ground 4. One brown color bull and one gray color bull has been recovered and seized accordingly from the possession of earlier arrested accused person, namely Biju Ahmed, son of so and so, and 3 numbers of cows have been recovered from his house,
lordship,
and seized in presence of witness.
in the 5, lordship, the accused person has been
That is
stolen
there.
cow along with. That means he is habitually doing this, lordship.
Specifically,
Specification is not there. Otherwise, lordship.
heard Mr. T. Goleta, learned counsel for the accused, and also heard Mr. K.K. Das, learned additional PP for the state respondent. This petition under section 439 service is prepared by accused Unlawful, who has been languishing in jail in connection with Hajo PS case number 102 of 2024 under section 380 IPC, edit section 411 IPC. Since 28/4/2024 for grant of bail. The above noted case has been registered on the basis of one FIR lodged by one Aurobindo Malakar. On board or he will be placed. The essence of allegation made in the FIR that it's going to is that. On 30/3/2024. No, on 29/3/2024 at about 11:45 PM at night, some unknown persons have committed theft of one cow and one calf in one Eon vehicle bearing registration number AS01EE 6555. Mr. Polita, learned counsel for the accused submits that the accused was arrested on 20/2/2024, and since then he has been languishing in jail as well. Mr. Polita further submits that that one brown color submits that three numbers of cow recovered from his possession, and the said cows he have purchased from whom you have purchased it.
Lordship, three vouchers are there, Lordship.
Page number
Page 28. Then, Lordship, it's a page 30. It is from Bazaar, Lordship, Market,
from
and
one
page 32.
Madhav Boisio and here of the
Darul Hasid,
from
Borketri,
Darul Hasid, and also and the other one
other one is from one private individual, Lordship,
Darul Hasid
Madhav
Borketri Alia Madrasa Bazar of Lohar Katha, and the other one
two from the Bazaar, Lordship, two from Bazaar, one from individual.
and in support of his claim, Mr. Polita has support of his submission, Mr. Polita has referred to annexure number 9, annexure 10, and annexure 11. The purchase receipt. And that the accused is innocent and now involved with the offense charges, and therefore it is conducted to allow the petition. On the other hand, Sir Keketas, a learned additional PP, has produced the case study before this court and submits that the stolen cow is yet to be recovered. An investigation is going on, and therefore Mr. Das has opposed the petition. Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents plus on record, and also produced the case diary with the assistance of Mr. Das, learned additional PP. It appears that the accused was arrested on 28/4/2024, and since then he has been languishing in jail as well. Further, it appears that 3 numbers of cows have been seized from the possession of the present accused. And said cows, as submitted by Mr. Kolita, was purchased by the present applicant from one Madhav
Boisio, Lordship.
Madhav Boisio, and 2 from the market. 2 from the market. From one Monul Arjo, Monul Ali.
Mojul Ali, it's a Bazaar, Lordship, Madrasa Bazaar.
Monul Ali. Further, it appears that the IO has achieved some progress in the investigation of this case. And having regards to the materials collected so far in the case in support of the allegation made in the FIR, and also considering the period of detention, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of life amount to the satisfaction of the CJM Nalbari.
Lordship, Hazu JMFC, Lordship.
JM first class Hazo, the accused being enlarged on bail.
Your case diary was called for.
Yes, diary received.
This lordship has perused the FIR page 14, your lordship. This allegation regarding the lordship regarding the stolen of some iron rod, your lordship, from the FIR, your lordship. And there is, I am not the name accused in the FIR, and I am the local contractor there. The police has been searching before me, searching me in connection with this case, your lordship. And the seized material has already been recovered also.
Yes, Gogol?
Yes, she is from the Motiur matter. That is the statement of Motiur matter, the open page diary. Article she is from Motiur.
But the present applicant is Sanjeev Hendik.
My lord, yes, 3 person connected to in this case, my lord. And then as
Is
per-
there any material against the present applicant?
that is,
Sanjeev-
my lord, they have done, yes, these 2 person, my lord. Present petitioner and one of his friend, my lord. Motiur says, my lord, Motiur from his position, my lord, those goods recovered. Goods already recovered, my lord.
Goods recovered in the custodial detention of this petitioner may not be required a lot for it. Will cooperate with the investigation, your lordship. Any condition.
Pardon me, Sir Al Mohan, learned counsel for the applicant and Mr. B.V. Gogoi, learned additional PP, but I still contact. Apprehending arrest in connection with Chitrago case number 36 of 24 under section 279 IPC. This application under section 438 CIPC is deferred by accused Lalit Hendik. No, Sanjeev Hendik for grant of PSP. It is to be noted here that above noted case has been registered under the basis of one FIR lodged by one Prasanto Buragumai, Assistant Executive Engineer PWRD on 6/4/2024. The essence of allegation made in the FIR dated so is that on 5/4/2024, some miscreants have stolen iron pipes from nearby area of RCC Bridge number 1/4 over Limo River at Sologuri on Korikotial. When the said materials were found and seized from a vehicle bearing registration number AA04BC 9094. Mr. Mohan, learned counsel for the accused, applicant submits that. What is your submission?
My submission is that, my lord, I am the local contractor. I have no request related with the alleged offense.
Pardon?
I am the local contractor, your lordship. I am doing contract work. I am no related with the alleged offense, your lordship. I being the local contractor, the police has been searching before me. Searching me, your lordship, in connection with this case.
That the applicant is a local contractor and he used to do contract works. And he has nothing to do with the stolen stolen iron pieces. And as he is a contractor, he is being searched by police and therefore, and he is ready to cooperate with the investigating agency and therefore Mr. Mohan contended to allow this petition. On the other hand, Mr. D.D. Gogoi, learned additional PP, has produced the case before this court and submits that the IOS collected incriminating materials against the present applicant. However, Mr. Gogoi submits that the stolen articles have already been recovered and seized by police. Where having heard the submission of learned advocates of both the parties, I have gone to the petition and the documents placed on record and also produced the case date. Where the case date indicates that the stolen articles have already been seized, recovered and seized by police. further it appears that the IO has collected some materials, no, some materials in support of the allegation made in the FIR against the present applicant. But it appears that the investigation, material part of the investigation is almost completed. And as the applicant has assured to extend cooperation with the investigating agency, this court is inclined to allow this petition. It is provided that on furnishing a bond in the event of arrest of the applicant in connection with Sipsagar PS case number 36 of 2024 under section 379 IPC. He shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with 102 like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition shall not leave the jurisdiction of CJM, Sipsagar without prior permission.
Highly obliged. Item 39.
39 diary not received from Hatigaon.
So we are not a name accused person, Lordship. May I pray one thing, Lordship? Let them to appear before the IO, Lordship. If we are involved in any way, Lordship, Lordship will recall my interim PN, Lordship. Because I am the employee of the main accused, Lordship.
Yeah, we will fix it on Monday.
Monday,
Let him
yes.
produce the case.
Yes,
then
Lordship.
we will finally protect you if there is no material against you.
Lordship. Obliged.
Item 40.
Last question call for the CD lordship.
Is CD received.
Hmm.
CD kon ase.
Okay, here in this case lordship, so allegation 353 lordship. So the basic case is lordship the 498A lordship, the husband and wife of the lordship. So the same day lordship, the 27/4/2024, the two affair was lost lordship. First lordship the 96, in between the husband and wife 498A, and the 97 is another case lordship, same day lordship. So when the call out by the police concerned the both family, husband family and the wife family. So
Now you are
Number-
seeking bail in which case?
97
or
lordship, 97,
97.
97.
So
case
is there any
very-
material? In
Yes,
the-
my lord, actually, my lord, husband residing at Kerala, my lord. So this FIR is against my lord in-laws. All they are my lord relatives and father-in-law, mother-in-law.
No, regarding this 353,
No such.
no material.
Only the pushing, my lord, pushing. Hela hesa.
Tell us.
No, is it not amount to preventing them from discharging official
That is
duty?
all right, my lord, but not so serious, my lord. That is only hela hesa kori jai, that is
Heard Mr.
preventing, that is
Arsikas,
all right, my lord.
Learned counsel for the applicant, and also heard Mr. T.V. Gogo, learned additional picture for the state response. This pair number 2 of order dated 9/5/2024. 2 and 3. The sense of allegation made in the FIR dated 20. On 27/4/2024 at about 11 AM. The informant along with police staff proceeded to the house of Musammat Hafizur Nehar to inquire about the FIR lost by her. No, lost by Musammat Hafizur Nehar. And then they were attacked by some unruly persons, namely Muhammad Jabbar Ali, Muhammad Afia Begum, and Muhammad Sukur Ali, and Gulzar Hussain Riazuddin. Gulzar Hussain and Riazuddin, and others, and prevented them from discharging their official duty, and abused them with abusive words. Mr. Das, a learned counsel for the accused, applicant submits that the applicants are innocent, in no way involved with the offense alleged in the FIR, and that they are ready to cooperate with the investigating agency, and therefore Mr. Das contented to allow the petition. Whereas, Mr. Das further pointed out that the case has been registered under section 447, 294, 353, 506 IPC, and except section 353 IPC, rest of the offenses are bailable offense. Whereas Mr. B.B. Gogoi, learned additional PP, has produced the case before this court and submits that. What is the stage of investigation, Gogoi?
Investigation, my lord,
Completed?
no, my lord, they are not appearing, my lord. This is 438 application, my lord. So investigation in progress, my lord.
Submits that investigation is going on. Witnesses are examined.
Some witnesses examined, yes,
And
never.
some witnesses are examined. Then the allegation level in the FIR are not so serious in nature. But having heard the submission of learned advocate of both sides, I have gone to the petition and the documents placed on record, and also urged the case daily with the assistance of Mr. Gogoi, learned additional PP. But in view of the materials collected so far in the case area, and also in view of the nature and gravity of the offense and the punishment prescribed for the same, as well as the stage of investigation, custodial interrogation of the present applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicants in connection with case number so and so under section so and so, they shall be released on pre-arrest bail under executing a bond of rupees 50,000 each, with 1 security of like amount to the satisfaction of the arresting authority. The above privilege is all subject to the following two conditions. First condition, they shall not leave the jurisdiction of Cesar Nagao.
Lordship, Grupo had PS, Lordship.
CGM
Poliabor, Lordship.
As is M. Poliabor.
Poliabor SDGM, Lordship.
Item number 43 forward.
Master Lordship.
May I please your lordship. Lordship, as per office note dated 9/5/2024, my lord, service is awaited, my lord.
What to do? Do you want to take crisis or will await service report?
Await service report, my lord.
Await service report. Office note dated 9/5/2024 indicates that neither ready card nor answer notice returned. Unserved notice issued to respondent number 3 received back by the registry. List the matter after 2 weeks awaiting service report upon respondent number 2.
My lord, there is an interim order. Interim may be continued.
Okay, till then interim order passed earlier shall continue.
Much obliged. 7 June.
Good order.
Timing item 37.
None appears for the applicant on call. Restes shall list the matter after 1 week.
Item 44.
May it please your lordship. My lord, will this case record was called for? My lord, this lordship also, my lord, in IA criminal number 1194, my lord, directed to my lord, after perusal of the record, my lord, or record, receipt of the record, my IA will be considered.
নোটিশ সার্ভ হল না নোটিশ ফার্স্ট থিং হ্যাঁ কোনো এপিআই করা নাই এখানটা সেই কারণে আমি অফ দিয়েছি কারণ নাম শো করে don't know.
My lord, there is a order in my lord IA 1194. Lordship.
নোটিশ সার্ভ হল না নাই কি রিপোর্ট আহিছে না
হ্যাঁ সার্ভ হয়েছে আহিছে
এইটো সুধি আছে যিটো সুধো সেইটো উত্তৰ দিয়া
মেইন এপিক অপেক্ষা কৰা নাই
নোটিশ সার্ভ হলেই হ'ল
on the plea of guilty, my lord, session judge, my lord, convicted my lord 5 years. So my lord, I pray for my lord, I have found a judgment of the Calcutta High Court, my lord, similar issue, my lord. Calcutta High Court, my lord, consider minimum punishment, my lord, 2 years, under section 14AB, my lord, and
So what do we want? Do you want to argue the matter in IA or in the criminal appeal?
it will be better, my lord, unless we may heard the matter finally, my lord.
Finally.
Finally,
So
giving a short date.
whether notice was served?
My lord, there was a delay in, my lord, we filed for condemnation, and that condemnation petition, my lord, respondent appeared, advocate appeared.
Your name not shown today, name not shown.
Pritam Kumar Hazong. Who was this respondent number 2?
My lord, he's informant.
He is a police official or
No, my lord. One, my lord,
private person?
Private person, my lord. His name is, my lord, Pritam Kumar Hazong. We made party, my lord, in delay petition, my lord, and accordingly advocate appeared, my lord, while disposing the delay petition.
এইটো কেতিয়ালৈকে কভাৰ কৰিছে
Condemnation. B. Chaudhary.
Yes, sir. Lordship, may director shown his name, my lord.
Who is this B. Chaudhary? Bapan Chaudhary or Biswajit Chaudhary?
My lord, B. Chaudhary.
মানুহটো চিনি পোৱা নাই
চিনি পাওঁ।
কি ফুল নেম কি
B. Chaudhary bin Jani.
বি
Idea appeared.
Yeah, heard Mr. Ziuddin, learned counsel for the petition appellant. Mr. Gogoi, learned additional PT for the respondent number 1. None appears for the respondent number 2. Mr. Uddin, learned counsel for the appellant submits that at the time of hearing of the interlocutory application filed under section 5 of the Limitation Act, Advocate B. Chaudhary entered a plea on behalf of the respondent number 2. And accordingly, it is provided that rest shall list the matter on third of June, and reflect the name of Mr. B. Chaudhary in the cause list for the respondent number 2.
I'll supply.
LCR has already been received, and on that day, endeavor will be made to hear and dispose of the entire matter.
May I please, your lordship? Lordship, as per order dated 18/1/24, we have taken steps, my lord. We have taken steps on, my lord, 25/1/2024. But nobody is appeared.
notice served, no?
Yes.
And I notice এটা কথা না তুমি স্টেপ লইছা কিন্তু সার্ভ হয়ে হইলো রিপোর্ট আসছে না
না।
হ্যাঁ that means not complete.
Yes.
Okay. itu non-paper governance, that is my answer. Good. Whether you have taken any step,
Yes, my lord, we have,
when?
my lord, in this case, my lord, we have newly engaged, my lord. As per my lord, earlier engaged counsel, they have taken steps, my lord. Statement, my lord.
But the office note states that no step has been taken.
But they told us, my lord, they have taken steps on 25/1/2024, my lord.
No, there is no record.
So, my lord, I pray, my lord, Behul Lordship will take fresh steps, my lord.
Okay, heard, Mr.
Really, my lord.
Learned counsel for the applicant. And Mr. B.V. Gogoi, learned counsel for the respondent number 1. The learned counsel for the applicant submits that he will take decisive upon respondent number 2. Accordingly, it is provided that step be taken upon respondent number 2 within two working days from today by registered post and also by usual process. This after 4 weeks.
My lord, June 1st week.
No, the question is whether notice could be served within a short period or not.
My lord, it's long pending case, my lord.
That's all right, but who is responsible for the delay? You people. You have not taken any step.
My lord, earlier 2 occasions, they have taken steps, my lord.
No, where is the record? Show the record.
My lord, some more times maybe 3 days or 4, 5 days, man. My lord, 2 more days.
Oh, taking step 1 week. Okay, 1 week.
1 week. Obliged, man.
47.
May it please your lordship. Today we have taken steps, my lord, or respondent number 2, my lord.
Today.
Yes, my lord, today.
Heard, miss?
R.S. Deuri, my lord.
R.S. Deuri, learned counsel for the applicant. And Mr. B.V. Gogoi, learned education for the state respondent. Ms. Deuri submits that she has taken step upon respondent number 2 only today. In view of above, it is provided that Registrar shall list the matter after 4 weeks. After 4 weeks, everything service report upon respondent number 2.
Obliged, ma'am. My lord, I cannot hear item number 37. So the matter may be taken up Monday.
Okay.
48.
Obliged, sir.
Lordship was pleased to issue notice, my lord, in this case. We have taken step, but service is awaited, my lord. But so far LCR is, my lord, LCR is received, I think, my lord. And there is an interim prayer, my lord, Lordship, you please to consider after receipt of the LCR.
Service complete হইছে না চেক করেছেন না রেকর্ড কেউ না করা
No, service is awaited.
Yes, my lord. But I have a prayer for interim, my lord. Lordship was last reported in last order, my lord. And this case was, my lord, fixed on 22/5. So unless, my lord, this is considered, my lord, my petition may be infractious. Because.
How?
Yeah, because it is for DW evidence matter. Already evidence of the prosecution finished now.
No, you have approached the court lately.
Plus. So, my lord,
So without a trial is going on and without hearing the other side,
so my lord,
the granting of stay.
last may fix, my lord, we have taken this, my lord, steps, my lord, all responding.
Heard Mr. Ziuddin, learned counsel for the applicant. The petitioner and Mr. B.B. Gogoi, learned additional PP for the state respondent. Office note dated 15/5/2024 indicates that service report in respect of respondent number 2 to 18 is awaited, are awaited. So recess is the matter after 2 weeks, awaiting service report upon respondent number 2 to 18.
My lord, interim prayer will be considered after this.
Okay, interim period of the petitioner will be considered after appearance of the respondents.
All right.
49.
May I please the lordship?
Yes.
My lord, in fact, this interlocutory application is filed, my lord. A small verification is sought for from my lord below. Lord, what has happened? Matter, my lord, relates to pendency light maintenance, my lord. That 30,000 had been, my lord, provided by the learned trial court below under, my lord, under the Hindu Marriage Act. My lord, and that order was put into challenge before my lordships, my lord. And my lord, the original order, my lord, may be pleased to find is at page 60. And the operative part, my lord, the page 64, the last paragraph, my lord.
Mr. Bhuya,
My lord.
so this is a civil matter.
Yes, my lord, because my lordship has disposed of that order, we want the clarification, my lord, my lordship's order.
What's that?
That's why, my lord. Before
What is that order?
my lord, or my lordship's order, which we are, my lord, seeking, my lord, is at page, my lord, 66. My lord, that 30,000 amount, my lord, which had been directed to be paid, my lordship was pleased to, after hearing my respected friend was also there on that day. My lord, that 30,000 has been, my lord, modified. That 15,000 I should be paid to my wife, my lord, and which I had agreed upon. And the remaining 15,500 was required to be spent by myself, my lord. But my lord, as the order, my lord, reads as, and also a sum of rupees 15,000 being the maintenance to the respondents, my lord. That's why, my lord, my learned friend preferred an application before the trial court that, my lord, I should pay as a whole 15,000 to my wife and another 15,500 for my children to the wife, my lord. Actually, my lord, that was not the order modified, my lord. My lordship was pleased to modify that 30,000 bifurcated into 2 parts, my lord. So that's why, my lord, that my lord may be pleased to find that in the last paragraph is modified to the extent indicated above, my lord. So, my lord, till date I am agreed upon that I should pay, my lord, 15,000 to my wife and the rest 15,500, or it may require more also. At the, my lordship is well aware, my lord, that the expenses is nowadays, my lord, enhancing.
You are for the wife?
I am for the husband, my lord.
Husband.
Husband, my lord. I have to pay, my lord.
Yes.
So now my learned friend is saying that.
At the very behest, I'd like to say, my lord, the application is filed under section 152, my lord. That is not maintainable, my lord, because, my lord, that section 152 of CPC is for amendment of judgments, decrees and orders, my lord. If there is any clerical or arithmetical mistake.
No, my
First,
lord, we have filed.
my lord, what they are trying to say is that 15,500 and 15,000, we are seeking differently. If your lordship may come to page number 69, my lord, the application which we had given before the learned trial court. Here we, my lord, had asked for 15,000 area maintenance at the rate, and the area maintenance was 1,20,000 lordship. So our application was that this honorable court had demarcated that 15,500 should be paid for educational expenses and 15,000 to me for my maintenance. Well, we seeked only 1,20,000 the area maintenance which has to be paid to us, not the educational expenses. Educational expenses he is paying 15,500. He was 15,000. He was not paying to us. Thereafter, my lord, he filed his objection. That is at page number 71. If your lordship comes, my lord, he interpreted before the learned trial court that this honorable court has passed an order, and he has to pay 15,000 only from the date this honorable court passes order, not from the date when the application for interim maintenance was paid. Thereafter, my lord, the learned trial court had passed another order stating that no, it is crystal clear from this honorable court's order that the 15,000 has to be paid way back from the date when I filed my application seeking interim maintenance. My lord, the petitioner came before this honorable court again under another CRP, which your lordship will kindly take a look at. My lord, page number 79.
77.
79 is the order, my lord, the final order. My lord, in this order, my lord Justice Devashik Gupta, my lord, he had finally disposed of that application. And if your lordship comes to page number 81, my lord, this is only regarding 1,20,000, my lord. The above paragraph of your lordship's judgment, my lord, was shown as paragraph number 8, having considered all facts and circumstances so and so. Civil relief petition is disposed of by directing the petitioner to pay monthly educational expenses for his 2 children to the tune of 15,000 per month, and also a sum of 15,000 being maintenance. My lord, now at paragraph number 6 of page 81, my lord, will see that this court further finds it relevant to take note that the respondent herein had filed an application on 11/7/23 stating inter alia that the petitioner herein had not deposited the pendency like maintenance of 8 months, my lord, totaling to 1,20,000. This is only 15,000, my lord, and as such sought for direction upon the petitioner herein to clear the balance area. It further reveals that the petitioner herein has also submitted a petition on so and so, that it is a fact that he has deposited 15,000 towards so and so in respect of the month of July in the court, and as this court had directed him to pay a sum of rupees 15,000 as maintenance. It was also mentioned that so far as the educational expenses are concerned, the petitioner herein have been paying the educational expenses regularly separately. Further to that, it was mentioned that the liability to pay maintenance towards commences from 27/6/23. My lord, that is your lordship judgment 27/6/23, what he has stated.
No, that has been
Only, and
negated.
not retrospectively from the date of filing. My lord, at the last, my lord Justice had given a at page number 84, my lord, that 1,20,000 was bifurcated in the monthly installment of 30,000. This is arrear, my lord. Even the petitioner has defaulted in paying that money. And regarding coming before this honorable court under 152, my lord, this, my lord, is not a review. Your lordship will only see whether there is a clerical or arithmetical mistake. There is a clear bifurcation, 15,500 towards educational expenses and also a sum of rupees 15,000 towards maintenance. My learned friend would have, ought to have filed an appeal before the Honorable Supreme Court, my lord. My lord, with this clarification, what will happen, my lord, is that if the earlier CRP is tingled with, my lord, the subsequent order passed at page number 81
No, my lord,
will not have any clarification, my lord.
We are not against paying of any maintenance, my lord. We are not even, I am ready to pay the arrear maintenance also. My lord. There is an order of this honorable court, my lord, and I have, my lord, considered with the my lord discussion with my client that I will pay the arrear maintenance of 1,20,000. Some difficulty is going on. That has been, my lord, up to the month of July, the limitation has been provided. Now, my lord, only thing is that this 15,500, my lord, which I have to pay for the, my lord, expenses of my children, that, my lord, may only a clarification is required. That is required to be paid by myself, not to my wife, my lord. Now, they are claiming that they, my lord, the amount of 15,500 that wife is entitled. That much clarification, my lord, we are paying for me. And we have come up with 151, read with 152, my lord.
My lord, with 152, you cannot invoke this honorable court's jurisdiction under.
No, my lord, I do not have.
My lord, you ought to have filed a review, my lord.
I have, my lord, 151, read with 152, my lord. For this type of clarification, my lord, I think my lordships had the jurisdiction, my lord.
My lord, I have placed 2 judgments, my lord, under section 152, whether.
Because the one thing, we'll fix another date. We'll hear you.
My lord,
my
lord, only thing is 152, whether under 152, my lord, your lordship can tingle with.
No, may not be 152 may not be attracted, but 151 is there.
My lord, then in case it ought to have been a review, my lord, of your lordship's
Pardon?
order. My lord, they ought to have filed a review, my lord, within the time prescribed. My lord, this clarification I don't see, my lord, because there's clear stand.
Okay, we will hear you.
Yes, my lord.
We are
that
not
can be.
going to dispose of the matter today.
Mine.
Heard Mr. A. Bhuya, learned counsel for the applicant, and Mr. Your good name,
My lord, A. Bhatra.
A. Batra, learned counsel for the respondent. This interlocutory application under section 151, reduced section 152, say, CPC
Mine.
is preferred by the applicant Manojyoti Raskwa for correction, and or clarification of the order dated 27/6/2023 passed by this court in CRP, which will begin IO number 181 of 2023. Dispose of on 27/6/2023. Peruse the petition and the documents placed on record, and also peruse the order dated 27/6/2023. List the matter on suggested then.
Mine.
My lord.
Oh, further hearing.
Apply.
Number 58. 58.
Maybe, Lord Lordship. I is filed for my lord to implicate informant as party respondent. Foxo is there, my lord.
Please, Devgan, my lord.
No, how this 179 will be applicable in your case?
My lord. Well, 179, 186.
Consequent NCOs, where consequent NCOs? Where the informants are living?
Yes, my lord.
Mhm.
Well, where the informants are living, my lord, that has never been urged in the FIR, my lord. Because they said some of the residents are from Rongia, natives are from Mongoldoi, even in the Rongia PS case.
And the training
Now, my lord,
camp
we have a
was organized
situation.
in Rongia also,
Yes, my
Rongia.
lord. Now we have a situation, my lord. Even in the Dispur PS case, my lord, the complainant is from Bayhata Sariali. And he never received any training within the jurisdiction of the Dispur police station.
And what is the stage of investigation in these cases, Mr. Nath?
Well, for 20 months, the investigation is pending. No report has been filed. We have joined investigation. 41A complied, even 91 complied.
But up to date position, I have to take.
None of the cases has attained finality, my lord. So far as investigation is concerned, for 20
Mr.
months,
Nath,
the
you do one
investigation is
thing,
pending.
you produce a case diary of all those cases. We will see.
My lord.
We will see.
My lord, in fact,
And
if
you have to explain whether what same transaction means.
My lord.
Whether the principle of same transaction as discussed in the cases referred by you will be applicable here or on next day. Huh? Heard Mr. S. Duff, learned counsel for the petitioner, and Mr. Dina, learned senior government advocate for the respondent number 126, and Mr. P. D. Bunyas, learned counsel for the respondent number 7 to 10. Heard in part, resist and list the matter on suggest.
Lordship, may give you one week time, my lord. I have to take the
Yeah,
case diary.
we'll give, definitely will.
Lordship.
And in the meantime, Mr. Dina, learned senior government advocate, shall produce the case diary of Ramia PS case number so and so, Tihu PS case number so and so, and what are the other numbers?
Rongia, Dispur, Tihu, and Dhula.
Okay.
1, 2, 3, 4, at page 23. Lordship.
As of now, there is no case pending in Rongia police station, man, because that case has been transferred to Dispur. So, my lord, Dispur, there are 2 cases. And the third case is.
What are the numbers?
Yes, my lord.
You furnish the numbers?
Yes,
The two court master.
My lord.
142. 4th June. 4th June. Or let it be on 3rd or 5th. May not be on the board.
Tuesdays and Thursdays is okay. Tuesdays and Thursdays are better. Tuesday and Six.
At 2 p.m.
6 June, my lord.
6 my lord. On
6
six.
June. Okay, at 2 p.m.
Lord, Lord,
Diplo.
Lord. All right.